Yes, be ready. Start. If the court does not reject the application for the grant of anticipatory bail and makes an interim order of bail, it should forthwith give notice to the public prosecutor or government advocate. Stop. The question of bail would then be re examined in the light of the respective contentions of the parties and the presence of the person seeking anticipatory bail in the court should be made mandatory at the time of hearing of the application for the grant of anticipatory bail and provision made for certain exceptions so as to cover cases where a person is sick or cannot appear in court due to certain unavoidable circumstances. Stop. A parliamentary bill number 56 of 1988 was introduced in the Lok Sabha on 13th May 1988, clause 49, whereof sought to amend section 438 by inter alia, omitting the words or the court of session both from subsection within bracket 1 and within bracket 2 of that section, but the same had not been carried out. Stop. In May 1994, the Government of India introduced the Code of Criminal Procedure within bracket Amendment Bill 1994 in the Rajya Sabha. While the bill was before the Parliamentary Committee on Home Affairs, the Government of India made a reference to the Law Commission to undertake comprehensive revision of the Code of Criminal Procedure and suggest reforms in the law. Stop. Accordingly, the Law Commission submitted its 154 report on the subject. Stop. It may be expedient to reproduce the relevant extracts of this report here in below, insofar as the same relate to anticipatory bail. Stop. New para. Since the introduction of the provision of anticipatory bail under section 438, its scope has been under judicial scrutiny. Stop. The leading case on the subject is Gurbaksh Singh versus State of Punjab within bracket 1980 to SCC 565. Stop. The Supreme Court reversing the full bench decision of the Punjab and Haryana High Court in this case, which had given a restricted interpretation of the scope of section 438, held that in the context of Article 221 of the Constitution, any statutory provision concerned with personal liberty could not be whittled down by reading restrictions and limitations into it. Stop. Since denial of bail amounts to deprivation of personal liberty, the court should lean against the imposition of unnecessary restrictions on the scope of section 438, especially when no such restrictions have been imposed by the legislature in the terms of that section. Stop. The court also held that the conditions subject to which the bail can be granted under 437 within bracket 1 should not be read into section 438. Stop. While allowing unfettered jurisdiction to the High Court and the Court of Session, the Supreme Court. Stop. Over.